All right.
All right, Your Honor. Thank you so much. I appreciate the generous
Yeah,
allowance of time.
not a problem, and we appreciate you for your late entry into this process.
Of course.
We are here for a civil action
He doesn't even.
between the plaintiff, Mr. Damien Tinkerman, and two parties. One, Mr. Bili Hendrixx and Mr. John Fisher. I want to start out by thanking the parties that did attend today. I will be putting a note down here as well as pertaining to Mr. Fisher, um, that he does have until the end of this case to arrive. Should he fail to arrive, a bench warrant will be issued for failure to appear to a summoned court
Ooh.
Ooh.
and that will be at my discretion. Before we begin with the reading of the statement of claim, does either side have any pretrial motion?
Yup.
Okay, from the plaintiff.
Motion for directed verdict based on the evidence and the lack of evidence provided from affirmative defense from the illegal towing.
I know what that meant.
Okay. Rebuttal to that. Basically, she's saying she's motioning for a directed verdict based that, no evidence was put on the docket to revert that this was a legal tow.
I understand, Your Honor. I would pretend that the defense in this case was that my client did not, when my client was making statements related to their availability, that is a clear sign that they do not find that they are
What's up?
guilty of or will be found liable, excuse me, as this is a civil case, of course. The fact that they are in conversations to be available tells me and tells the court as well that he would like to, move forward and defend his honor in this case. Additionally, I've spoken with my client, and he is looking forward to testifying in this
Okay.
case, and he would like to present that as a part of his defense and evidence. And so the plaintiffs in this case are more than happy to question him on this. And of course, in any civil case, both sides have a right to depose witnesses, gather evidence. And in the climate of the city that we're in, I think that it is more than appropriate to give us the opportunity to at least testify before we go to an extreme of direct verdict.
Your Honor, he said the plaintiffs would be more than happy. I would request that they don't speak for me.
Duly noted.
Thank you, that's all.
Given the nature of the matter, I am going to deny your motion at this time. Mr. Fisher was without counsel until now and may not have been aware of procedure on the docket as far as submission of evidence. While we understand that the burden of proof for a civil matter is through a preponderance of evidence, I would like to at least hear arguments from either side. So that motion is going to be denied at this time, Counselor.
No problem. Thank you, Norman. We appreciate it.
Okay, understood. Any further motions, or can I begin with the statement of claim?
You may begin.
No motions, Your Honor.
All right, fantastic. Then I will read out. The statement of claim reads as follows. Damien Tinkerman has experienced his vehicle being towed and impounded without just cause. Despite being parked legally, Mr. Tinkerman's vehicle was ticketed and impounded, incurring unwarranted fees. This claim seeks restitution for the financial losses and stresses incurred due to these erroneous actions. Relief sought is a reimbursement for all impound fees incurred due to the erroneous towing of $600. Further punitive damages of compensation for time of distress caused by the repeated unlawful impoundment of the vehicle at $1,000, and special damages being a formal retraction of all wrongful impounding actions. Okay. With there being no additional pretrial motion, I will open the floor to opening statement. Plaintiff, you're first.
Your Honor, the evidence clearly reflects a legally parked vehicle, and the defendant's state ID is listed on the impound information on the day in question. The facts and the evidence will show that they illegally towed and impounded my client's car, causing him undue harm. We are also asking at this time that if they are so found liable and the damages are not found to be sufficient by this court, that they be forced to also advertise Damien Tinkerman's music. Thank you.
Okay. Mr. DiVincenzo, your opening statement, please.
Thank you, Your Honor. First, I want to make it very clear that as I'm coming in at the 11th hour on this, I hope that this court and that the plaintiffs will bear with me. I may make a couple mistakes here or there, but I am going to do my best to be a vociferous advocate for my client in this case. Now, my client, as the evidence will show, John Fisher, was in fact a legally operating, state operated tow truck driver. Now, at the time that this towing incident had taken place, the state of a lot of the towing operations were very up in the air. Those that were attempting to do the good work of properly escorting vehicles that were illegally parked away from the areas that were violated. There was not a clear procedure or messaging from the government on a lot of this. And so there may have been some mistakes as regards to photographing or not. However, having said that, my client here is not the one that actually issued the violation. As it shows on the impound information, the issuer was Bili Hendrixx. And as he is not here to testify as to the condition when he initially issued it, that is the prime case that we would portend, is that if the individual who had marked the vehicle for tow is not here, then that certainly pokes a hole in what the plaintiff is arguing. Additionally, my client here is willing to testify that when he arrived at the scene of the vehicle, it was in fact illegally parked. So he may have not been the one that was issuing the ID, but when he was there, it was in fact illegally parked.
Sorry,
So
which one issued? I was confused. I just want to clarify.
yeah,
Which one are you
Bili
saying issued?
Hendrixx, Bili
Hendrixx?
Hendrixx is the one that issued it and saw the vehicle. And by the way, I would say also, I have been a tow truck driver myself, and I have done impound work myself. And I can tell you that the issuer ID is the individual that actually looked at the vehicle and said, this vehicle is illegally parked. That individual is Bili Hendrixx. However, Mr. Fisher is the individual that responded to that call. And so his level of duty of care and his responsibility is shifted and completely different, is what we would argue. Lastly, we would argue that there is not enough evidence to support the damages. As we see here in the plaintiff's case, the compensation for time and distress caused by repeated unlawful impoundment of the vehicle at $1,000 is not properly proven by any form of pay slips, evidence of loss of wages. We don't even know where Mr. Tinkerman works and what the value of that means. We don't have any way to truly value it. And so we would ask that that part of it be dismissed as well by the end of this verdict. Ultimately, we ask that you find Mr. Hendrixx and Mr. Fisher not liable for what is their job as a properly valued state tow driver. Thank you.
Thank you.
Your Honor, plaintiff has a motion at this time based on respondent counselor's opening statement to rule of negative inference regarding Mr. Hendrix's testimony or lack thereof.
Take it under advisement.
Thanks.
All right. With opening statements concluded, we will open the floor for testimony. Will the plaintiff be testifying in this matter?
Indeed.
Okay, Mr. Tinkerman, come on up to the stand.
Why are you walking so slow?
He's goth.
All right. Damien, can you please raise your left hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury? So help you, Ollie Sykes.
Ooh, obscure one. Hell yeah.
All right, the witness is sworn.
Thank you, Your
Mind
Honor.
if I stand?
You may.
Sick. Studded.
One sec. Damien, were you driving your vehicle on January 17th?
Yes.
sorry, wrong day. January 7th. God, okay. I had a
Yeah,
mixture.
I mean, I
one.
drive
January
every
7th.
day, so yes.
Okay, great. Is the vehicle in evidence shown? Is that your vehicle?
Yes.
Objection, Your Honor, leading.
Yes or no questions aren't inherently leading.
Uh,
Sorry, did you need me to rebut?
No, so yeah, that's going to be correct. She's making a direct point to the evidence, which is the plaintiff's B, and is asking an open-ended yes or no question. That objection is going to be overruled.
Thank you, Your Honor.
But yes, that is my car.
Right. Is the plaintiff's A screenshot of impound record? Is that vehicle information referencing your vehicle there?
Yes.
And did you have to pay the fee to release or retrieve the vehicle?
Yeah.
How much did you have to pay?
600 plus tax.
Is that referenced in the bank account record in the plaintiff's C?
Yes.
And in the plaintiff's B, your vehicle is shown to be legally parked. Is that, can you just clarify, where is that? Where is that parking lot?
Outside of my former employment, Senior Buns,
Okay,
in
so
the parking lot across the street.
okay, thank you for that. When you left your vehicle, it was shown as you had taken the picture.
Yeah, I literally parked there every single day. That was considered my spot because I was a manager there.
All right, perfect. When you came back out, where was your car?
Gone. It was impounded.
Did you have any idea of what had happened to it while you were inside the Senior Buns?
Nope, I was shocked. 'Cause I
Objection,
was-
Your Honor. This is speculation. Asking the witness to speculate is improper.
Do you want me to rebut?
Well, no, I can take this one from here.
Cool.
The question, counselor or Mr. DiVincenzo, is if he had any idea what had happened. That can be answered with a yes or a no. If he knows what happened, he can speak to it. But if the answer is no, I will not allow him to speculate in nature. The answer would stop at no.
Okay, understood.
Okay, you may continue.
No further questions at this time, Your Honor.
Cool.
Okay, floor is open for cross-examination, Mr. DiVincenzo.
All right. So, how you doing there today, sir? This
I'm
beautiful day.
fucking vibing.
I fucking love that. That's fantastic. You know, I'm vibing too. You know, I absolutely love your tattoos. Where'd you get those?
A friend
I'm gonna
of mine.
object. I'm gonna object to relevance.
I was going to, but I also
Okay.
wanted to
All
know
right,
the
all
answer.
right. That's fair enough. That's fair enough. I'll withdraw the question.
Yeah.
That's all right. I do appreciate the court's time here. All right. So, Mr. Tinkerman, did I pronounce that correctly?
You did.
Okay. All right. So, what is your current employment is at Senior Buns? Is that
Not
correct?
anymore. No, it was at the time.
Okay, I was going to object. Damien, can you wait? I'm sorry, Your Honor, could you please instruct the witness to wait 3 seconds before answering so I may have a moment for getting the objection out?
Apologies.
Take a brief moment before answering.
Understood, Your Honor.
Last question and answer will remain on the record.
Thank you, no problem, I understand.
Okay. Would you like me to ask it again, Mr. Tinkerman?
I just stated it would remain on the record. You said your employment was at Senior Buns. You said it was his previous employment.
Oh. The
No
answer
longer
was that.
works
Okay,
there.
I understand.
Correct.
Yes, very good. Okay. So to clarify, January 7th is when you say previously, you're talking about January 7th is part of that previous, yes?
Correct.
Okay. All right. Now, do you know how much you are paid as a manager at Senior Buns?
Objection, Your Honor. Scope?
I'll take a rebuttal.
The plaintiff is asking for punitive damages in the form of compensation for time and distress. So I'm trying to understand how he's valued as a manager at Senior Buns.
Sure. Punitive damages are inherently punitive, counselor. They are at the court's discretion and are not subject to that same burden of proof. For compensatory damages, if she were saying for lost wages, specifically pertaining to lost wages while he was working, that would be filed under compensatory. It would not be filed under punitive. Give me 1 second. I'm in court. You'll need to call me back. So inherently, this does not cross into the scope at this time. No
Okay,
claim is
all right.
being made pertaining to Mr. Tinkerman's wages.
Okay, very clearly understood. Then appreciate that, Your Honor. All right.
Thank you.
So moving on, Mr. Tinkerman. So
Mhm.
let's talk about the events of January 7th. So
Mhm.
you stated under the direct examination of your wonderful counselor here, Miss Fitzpatrick Thoroughbred.
Not Miss Fitzpatrick. Yeah, Mrs.
Miss,
Thoroughbred.
oh,
If
oh,
you'd
oh,
be so
you don't do the
kind.
hyphen thing? You don't do the hyphen
No,
thing?
I
You
took his
do it-
name.
Okay, all right, beautiful. Chendanya, fantastic. All right, Miss
Thank you.
Thoroughbred, Counselor Thoroughbred. Under her questioning, you stated that you park there quite often in that parking lot. Yes.
Correct.
Okay. Now, on that day that you went to see your vehicle, um, you stated that you took a photograph of your vehicle prior to walking into the establishment. Yes.
Correct.
Okay. Now, this photograph, do you have a timestamp of when this photograph was taken exactly?
I could probably get it.
Okay, fantastic. So then you wouldn't have any problem producing that to the court as a part of their understanding of evidence in this case. Yes?
I could try to
We're-
figure it out.
Objection,
I'm
Your Honor.
gonna-
Discovery is
I'm gonna-
closed.
Yeah, we're beyond that point. We can't introduce new evidence upon our beginning of the court case.
Oh, interesting. So the photo stands. Very clearly understood, Your Honor. Thank you.
The photo stands as is, right? I won't be considering any new or newly entered evidence in trial.
Interesting. Okay. So, Mr. Tinkerman, you stated that that parking spot is considered your quote unquote your parking spot. Is that correct?
It was at the time, yes.
Okay. So, but the government never told you and said to you that is your personal parking spot, correct?
Objection, Your Honor. Weird.
Your Honor, may I rebut?
I'll hear a rebuttal.
This case is about illegally parking on state property. That is why cars are towed for illegal parking. So therefore, it is the state's responsibility to understand who parks where. For example, if there's a court judge that has a court judge reserved parking spot, then it would not be illegal because they're a judge. So I'm trying to make clear to this court that that parking spot is the people's spot, not Mr. Tinkerman's spot.
I have one response, Norman. It's that we don't even have assigned
Sure.
parking spots, though goddamn I wish we did.
Yeah, look, I'm not going to get caught up in the semantics of my spot versus a legal parking spot. I can take a look at the evidence and see what is determined to be a legal spot or what isn't. I don't want to get lost in semantics here, because
Okay.
largely I don't think an assertion of whether it's his or the state's spot particularly matters in this sense. Your objection is going to
Okay.
be sustained, counselor.
Okay.
Thanks.
Very good. I'll move on. All right. So, the parking spot that others told you was yours. You went and you took this photo. You went inside. Now, how long would you say approximately were you in the senior buns before you came back out?
Half an hour to 45 minutes, roughly. Definitely under an hour.
Oh, half an hour to 45 minutes. Okay. So you weren't just standing on the corner looking at your car for 30 to 45 minutes, right?
No, I'm not a psychopath.
Okay. I wouldn't dare presume to impugn your integrity in that regard, Mr. Tinkerman.
No, you wouldn't.
Of course not. So, Mr. Tinkerman, I've just got one final question for you. You ever done towing yourself?
Yes.
Okay. No further questions, Your Honor. Oh, unless my co legal aid would like to ask any questions.
I do not, Your Honor.
All right.
Counselor Thoroughbred, anything on redirect here?
Sure. What's your music production called?
Sorry, I'll elaborate. What do you mean by music?
Is it your music? Do you have a band name? What's your band name? You're asking for them to
Just,
advertise it.
I mean, I have a side project known as Fatal Incursion. But
That's what I was
most of my
looking
stuff
for.
Is, yeah.
Thank you. No objection. Nothing pending. Strike everything after the band name.
Was that self-promo?
The self-promotion is stricken from the record.
Great.
Mr.
Thanks,
Tinkerman,
Your
you
Honor.
can step down.
Poggers.
Mr. DiVincenzo, is he marked for recall?
Let me confer with my counsel.
Shit. Plug.
Perfect. And then I got stricken from the court record, so you didn't look like a shameless self-promoter.
All right. We for the purpose of dotting our T's, crossing our I's, will we call him? Though we likely will not have any questions, but just in case.
What the fuck, Damien?
I mean, he's gonna
Fucking
remain here
good.
either way. So.
Yes, that's what I
Dare
figured
you be
anyway.
so
So
duly
good.
noted.
Yeah.
All right, duly noted. Counselor Thoroughbred, anything to point out? Any additional witnesses or evidence you'd like to highlight?
Sorry, Damien was trying to mosh pit with me. Simply the evidence provided, Your Honor. I know how you know how to do your job. I'm not going to tell you how to do it, but please do look at it. That's all.
All right, cool. Does the plaintiff rest?
We do. The plaintiff
Alright.
rests.
All right, fantastic. Defense. Switch over to you then. Will you be calling any witnesses at this time?
Yes, we will, Your Honor. We'll be calling one of our wonderful clients here, Mr. John Fisher, to the stand.
All right, Mr. Fisher, come on up. Be taking a seat over there to my right.
Oh, it's all coming back.
Before you do, please raise your left hand. Make sure you are yelling for the court. Do you swear to tell the truth, the whole truth, and nothing but the truth? Under the pains and penalties of perjury, so help you, Nikita.
Yeah, I do.
All right, you are sworn in. Counselor DiVincenzo, let him get seated, and you can go ahead again.
Okay, fantastic. Thank you so much, Your Honor. All right, Mr. Fisher. Appreciate you coming down to this court. How's your day today?
Yeah, pretty good so far.
Okay, all right. But it could be better, right?
Objection, Your Honor. Who asked?
I'm asking. I think it's quite relevant. If he's not feeling too good, we should, check him out, get EMS going, maybe.
Has nothing to do with
Sure,
the bearing of the events.
I'm gonna say
Music
overruled on
record
who
has
asked
nothing to
because
do
he
with
has
that.
asked, but I am gonna sustain on leading because by inherently
okay,
asking by
alright.
asking you could be better, right?
Okay, all right.
Classic Oliver Hull.
All right.
So
I'll rephrase. I'll withdraw the question then, Your Honor, and I'll rephrase.
stay away from the the right type thing.
Okay. All right. Very, very, very clearly understood. Thank you. All right, Mr. Fisher. Let me ask you this: do you actually, you know what? I'm just gonna withdraw this line of questioning. Let's move on. So, Mr. Fisher, you what is your current place of employment at this time?
I currently work at the tow yard.
Okay. And on the date of January the 7th, what was your employment at that time?
Tow yard again.
Okay. And how about before January? How long have you been a tow truck driver?
For definitely a good few weeks now. I was doing grime beforehand, but didn't really work out. Didn't quite like it, so I quite enjoy towing.
Okay, fantastic. When let's talk a little bit about that profession. So, how does the tow driver employment work? Walk me through it. What is the day of a tow driver like?
We'll go into the office.
Hold on, pause.
make-
pause, sir.
Objection, Your
Counselor,
Honor. Calls
is
for
there an
narrative.
All right, I can rephrase the question, Your Honor.
Yeah, that's good.
Okay.
Don't leave it that open ended. Just ask
Yeah.
if you can describe basics.
Yes.
Duties and responsibilities type deal.
Very good. Mr. Fisher, what are some of the responsibilities that are assigned to you as a tow truck driver?
Objection, Your Honor. Relevance.
Your Honor, this is a case
I-
about
I don't need to. I'm going to overrule in this instance. Responsibilities will pertain to the individual's duties while on duty as a tow truck driver, which is inherently what's bringing us here today. Your objection is going to be overruled. You may answer the question, Mr. Fisher.
Thank you. So from day to day, if we see illegally parked cars, we will report them to the office, and obviously we do recover vehicles, take them to the impound, and also do like a little bit of roadside repair if tires are blown, wheels are falling off of cars, etc.
Okay. And who gives you these jobs?
So if there is a impound job to go and attend, generally there would be an issuer who has found the vehicle. They would call in the job to the office. The office would disperse it to the closest unit, which would be one of the tow truck drivers to then go and collect the vehicle.
I see. Okay. Now, is there anybody else that is a part of the employment of tow truck driving that assigns you jobs? Is there anything else?
Not as far as I'm aware. Apologies.
Okay. Okay. All right. Do you are you familiar with an individual by the name of Towington?
Objection,
yes.
Your Honor. Relevance.
Your Honor, I'm happy to explain the line of questioning here, if I'm allowed.
I'll hear a rebuttal. But
Yes. So, in short, the defense in this case is arguing that
there actually a man by the
the
name of
responsibilities of
No
a
idea.
tow truck driver were not as clearly defined and lined out at the time that Mr. Fisher was employed, January 7th. There wasn't a memo sent out by Mr. Towington, hey, you got to take a photo of this or that.
Objection, Your Honor, to this. Facts not in evidence.
But that is the reasoning for the line of questioning, Your Honor. I'm trying to introduce
so that can be produced through testimony. Then I get what you're getting at here, counselor. Both of
Hearsay.
you, actually.
Okay, great.
And I'm going to grant an objection for hearsay. I don't believe Mr. Tom Towington is able to come to court to speak for any of those.
I see, Your Honor. Okay.
Mhm.
Okay, I'm going to try this line of questioning a different way. Would you like me to cease this line of questioning, or may I continue?
If you can find another way to get to it, you know, you know what, Counselor Thoroughbred, do you mind if I kind of give the straight line path to the question he's trying to ask here?
I
for
would
ya?
love that. Go. Learning cart. Absolutely.
Sure.
Go ahead, Judge
Okay,
Adams.
all
It's
right, fantastic.
absolutely your prerogative.
Sure.
No
You should,
objections.
you should ask the witness something pertaining to, well, how do you determine if a vehicle is illegally parked? And how do you document that? You know, ask those types of questions.
I
You
see.
know?
Okay,
Mm.
very good.
Ask him directly, not about what other people may think.
Yes, I figured to go down that line. However, I wanted to make sure I'm not diving into improper hearsay testimony. So, thank you. I appreciate the floor, Your
This
Honor.
is why you are asking him directly of his knowledge.
Okay, very good. All right. Now, I'm going to ask you then, Mr. Fisher. Excuse me for all that doodly dad in
No
the middle
problem.
there. So, when you go out for a tow job for illegally parked vehicles, how is that job sent to you?
It's sent to us via our phone.
Okay,
and we
by
just
phone.
accept the job through the phone, yeah.
Okay. And does that message say anything about legal liabilities relating
No.
to towing a vehicle? Okay. Does it tell you how to inventory a vehicle?
No.
Does it tell you that you need to take a photograph?
No.
Okay. Now, let's move forward then to the actual date in question, January 7th. Mr. Fisher, were you working as a tow truck driver on January 7th?
Correct, I was.
Okay. And let me clarify, were you clocked in as a tow truck driver on January 7th?
I was.
Okay, very good. Now, when you were clocked in, walk me through some of the jobs that you had to do that day.
The same as I
I'm
stated
going to
earlier.
object to relevance from the bench here. To kind of keep this on track for you here, we're going to try and stick to the vehicle in question.
Okay, all right. I just didn't
Because
want to lead, Your Honor. That's all.
yeah,
Okay, so I'll just ask you direct then, Mr. Fisher. When you were clocked in on January 7th, did you receive a call about an illegally impounded vehicle near Senior Buns?
Not an illegally impounded vehicle, no.
Okay, what was the call you received at Senior Buns?
I'd received a notification on my phone that I accepted to collect a car in parking violation.
Okay, a car in parking violation. All right. Now this message, did it tell you that Mr. Bill Hendrixx had issued this tow impound?
No.
Okay. Now, uh, when you receive any of these jobs like this, are you notified of who exactly it was that marked it?
No, not at all.
Okay. Um, and so you accepted the job, right?
Correct?
Okay. Walk
That's-
me through then. Yeah, go
Oh,
ahead.
Pointer,
leading?
that's
Sorry, I
leading.
was gonna. Yeah.
For the
Oh, that's
record.
right. The right. I apologize. That
Sorry,
former
he was
habit. I
answering really
apologize.
fast. Could you ask him to
Yes, my
Norman,
apologies.
if you would,
Yeah,
please
just
ask him
take
to
a brief moment. Yeah.
Yep, that's
So,
fine,
Mr.
sir.
Fisher, go ahead and when I ask you a question, just take 5 seconds because the plaintiff may want to object. But don't worry, I'll knock that right out of the park for you. But I just need you to wait 5 seconds for all that to be taken care of. All right.
Doesn't need to be a full 5, just a brief moment.
Yeah, just literally enough word. Like, just give my brain 1 second to compute. You know what I'm saying? That's
Yep,
it.
understood.
All right.
Please continue.
Very good. So, Mr. Fisher. So, oh wait, let me ask you this also. Do you know Bill Hendrixx?
Nope.
Okay, so you never got a call from him saying, "Hey, I need you to tow this."
Nope.
Okay, all right, very good. So, you received the call for this senior buns situation. What happened next?
I got a location sent to me from the office. I attended the location, and that's where I found the vehicle illegally parked.
Okay, now that's a very tricky statement there. You say it was you saw it was illegally parked.
That's
Describe for
correct.
me what that vehicle was positioned in when you saw it.
Upon arriving, it appeared it had been maybe shunted from the back, and it was basically taking up multiple spaces,
I see. So,
as were several other cars also in that same car park.
okay, all right. So I'm gonna go ahead and direct your attention to plaintiff's evidence B, the photographic evidence. Do you see that on the evidence listings there, Mr. Fisher?
Yes.
Okay. So do you see that line just behind the vehicle? Do you see that?
Yes.
Okay. Now, your testimony is that the vehicle was in the middle of that line there. Is that what you're saying?
That's correct. It was taking up at least a coverage of 2 spaces.
Okay. All right. Very good. And then what'd you do next?
Wiggled my way in there and towed the car.
You wiggled your way in there. You towed the car. You did what you needed to do. Okay, fantastic. And then what did you do next?
Took the car to the impound lot, and that's where my job finished.
Okay, okay. So let's clarify on that. Job finished. So I know what you mean when you say that, but for the purpose of the court's clarity, what is the last step that you have to take as a tow truck driver when you deliver the vehicle to the impound lot?
I will pause here and inform you that the courts are aware of what it means to process an impounded.
Okay, all right. Then you know what? We're going to hold that then there, Mr. Fisher, because it seems the court is well aware of that. So we're just going to pause that then and move on to the next line of questioning, okay? So, then let's see. Okay. Let's move forward then in the line of events. So you brought it in, you impounded it at the lot. And then what'd you do next after that?
I went about my day, may have collected some more wheels at Mosley's, maybe got some lunch, like just waiting for my next job to come up.
Okay. Now, so let's then flash forward a little bit in the days after this. So, uh, did anybody contact you about the fact that you had impounded this vehicle in Senior Buns?
No.
Okay. And how were you made aware that there was a civil trial case against you?
When the docket was put up.
Okay. So, Mr. Towen didn't call up and tell you, hey, you messed up on this
I'm
impound.
gonna object on relevance.
Yeah, again, sustained, and again, we can't. It's going to be hearsay as well for Mr. Towing.
Yeah, on
Okay,
hearsay.
Right. All right. Then let me rephrase. Did anybody contact you at any point that works at the towing yard and told you you did this job incorrectly?
Objection, Your Honor. Again, relevance, etc. Everyone has the right to go through civil litigation. They are not obligated to attempt to mediate amongst themselves.
I'm not trying to argue that this case should be dismissed because it didn't go to mediation. What I'm arguing is that my client had a different set of responsibilities in this case than Bili Hendrixx. And so, therefore, his responsibility was to properly impound it at the time that this incident had taken place. And so that's one part of it. And the other part of it is to understand the mind of my client at this time, in that he was doing his job as he thought he was supposed to. So that's what we're trying to introduce. That's why it's highly relevant. And we're talking about punitive damages. That's what this gets to the heart of.
Okay. Here's where I'm at with this, Mr. DiVincenzo. I'm inclined to actually sustain this objection. As discovery goes here, right? The plaintiff found and has reason to believe that the vehicle was impounded improperly. There is no duty to report that is the case. And as far as I'm concerned, there is no duty for the tow yard to notify individuals if they quote unquote made a mistake. That's not something that's been established previously. And I don't know that that's something that necessarily happened and is within anyone's control, if you get my drift. So this line of questioning is irrelevant at this time. Objection's going to be sustained.
Okay. All right. I got one last question for you, Mr. Fisher. Do you believe that? Let me rephrase. Based on your professional opinion as a tow truck driver, do you find that you made any mistakes in this situation when you towed the vehicle?
No.
Very good. I will pass the witness to the plaintiff, Your Honor.
Okay, open for cross.
You testified that you had received a call and then went to go pick up the vehicle that had a quote-unquote parking violation. How long did it take you to arrive at the Senior Buns parking lot from you getting the call? Like, I want just distance traveled in time or in kilometers, miles, whatever, time preferred.
Maybe within a couple of miles, within a couple of minutes. Generally not too far away from each job.
So you were probably just around the corner then, not too far.
Probably not, no.
Couple blocks?
Couple
How would you
blocks.
say?
Yeah,
Couple blocks?
possibly.
All right, and you said that the vehicle was taking up multiple spots as well as other vehicles there in the parking lot. Is that correct?
Yes, that's correct.
Did you tow any of the other improperly parked vehicles?
Objection,
well,
Your Honor. Relevance.
I'll take a rebuttal.
Your Honor, where I'm trying to get to at this point in time is if you words. We don't know what car he actually got the call for, if there was multiple improperly parked vehicles. If there was, as he testified to, we have no evidence showing which one was the actual one he got the call on. We don't know if it was supposed to be Mr. Tinkerman's or another vehicle. I do think that's incredibly relevant.
I've got a rebuttal to that, if I may, Your Honor.
Sure, I'll take one.
Two things. Number one, we've already established indirect when I showed him plaintiff's B, the plaintiff's own evidence, and he positively identified that vehicle as the one that he had towed. That's number one. Number two, when you are a tow truck driver, and you, as the honor said this yourself, you know that when you are impounding a vehicle, when it's brought and processed, you can't process an incorrect vehicle. If that's the one that you got called for, that's the one that's going to get put in. So, with those two pieces of evidence in mind, that is the evidence that plaintiff is so desperately seeking.
I'm going to sustain the objection to relevance at this time. Given that, counselor, if you'd like, we can speak on this after the fact. But I understand what Mr. DiVincenzo is actually getting at here. And we can speak on this further.
Also, really good job. That was a great rebuttal. Really proud of you.
Oh, thank you. Appreciate it.
Sorry, give me 1 second to look at my notes. How long have you been towing?
For a good few weeks, probably several.
Could you identify an exact number for me? Because a good few weeks, I'm not sure if that actually goes back to January 7th or prior to that. Or if you're
Objection,
fresh.
Your Honor.
Sometime maybe
Objection,
4 weeks,
Your
maybe
Honor.
6 weeks.
What's the objection?
Hold on.
Pause.
Yep.
So,
Your
Mr.
Honor,
Fisher, when there's
asked
an
and answered.
objection on the floor, you stop answering.
Apologies.
Yeah.
Uh,
Objection,
you're
Your Honor.
objecting to asked and answered?
Yes, that's right. I already established in his testimony that he had worked at this tow truck, and the time period had already been established there. So that's already in evidence.
I'm asking
Sure.
for a clarification on the time period.
Correct.
exact
So
time period.
on the direct line of questioning here, it was asked, what was your employment? Who's your current employer? He said the tow yard. On January 7th, what was your employment? He was at the tow yard. You asked how long he'd worked there. He said a few weeks. She's asking for clarification on the enumeration of few.
I understand. Objection
So
will
we'll
be
go in-
withdrawn then.
Yep. Perfect.
How?
So, Mr. Fisher, if you could answer about how many weeks specifically.
So about roughly about 4 weeks, 4 to 5 weeks, say.
So had you doing math? What had you been towing for less than a week when you when the incident occurred?
Yeah, it sounds about right.
So just a few days.
No, a little bit longer than that.
According, if it was 4 weeks, then it would have been 4 days. You had been towing.
Yeah, like I say, it's probably about a week before. Yeah, maybe correct
Okay.
on that.
Okay. Were you an expert on how to spot illegally parked vehicles at that time?
No,
Objection, Your
that
Honor.
part
Relevance.
wasn't my job.
I mean, you have to tow. Oh,
Hold on.
Yeah, reject
Pause,
it. Yeah,
pause,
I'll shut up.
Pause. There's an objection for relevant. I'll hear a rebuttal.
Whether or not he was able to actually assess whether or not the situation merited the tow is incredibly relevant. It's quite literally within his purview, as was the responsibilities and duties question that opposing counsel asked under direct.
I'm inclined to agree. The objection is going to be overruled. I'll hear an answer to the question.
It was, were you an expert in being able to? He sort of had answered. Lad, can you repeat your answer?
No, definitely not an expert, but with a little experience and I mean knowledge through life. I can see an illegally parked car. I know whether it's illegally parked or not, but at the end of the day, that part of the seeing the car being illegally parked wasn't part of my job. I was just there to collect the car.
So if a car was legally parked but hadn't been reported for a parking violation, would you tow it still?
Objection,
the
Your
office.
Honor. Speculation. The plaintiff is asking my witness to speculate, which is highly improper for a court that would require relevant testimony.
Rebuttal.
I'm asking him directly on circumstances that he had prior testified to, just in the question before.
Sure, but you're phrasing it as if the car was legally parked.
I'll
would you have
rephrase,
towed it?
because he's right. It was calling for speculation. He did already
Yeah.
answer, but it was calling for speculation.
Objection's going to be again, Mr. Fisher. Wait a moment before answering, please.
Yeah. Do wait a
Apologies.
few seconds, all right? Count to like 1,000, 2, 1,000, 3, 1,000, all right?
Mhm.
Have you ever towed a vehicle that was that had been requested for a parking violation that did not appear to be parked incorrectly to you?
No.
What have you done in those instances?
I've simply called up the office and got them to cancel the job.
And have you been doing that the whole time you've been towing?
Yes.
Why didn't you this time?
Objection, Your Honor. The plaintiff is browbeating my client. He's already answered.
I believe you're looking for badgering here.
That's right. That one.
I'll hear a rebuttal.
It's gross. I'm going to ask for permission to treat the witness as hostile, even though it's inherently hostile. I'm going to go ahead and motion for that now.
He is inherently hostile. I'll hear an answer to this question, but I think this is the end of your line. The objection is going to be overruled.
It is. Why didn't you this time? Why didn't you this time, Mr. Fisher?
Because the car was illegally parked and not in the space where I would have cancelled the job.
I'm going to actually motion to strike his answer based on facts, not on evidence.
Your Honor.
As was the car in the rear of that photo that you put in as evidence.
Yeah, I'm gonna deny the motion to strike.
That's all right.
His testimony is from his personal account.
I understand. That's all right.
All right.
It was worth a
Anything on
try.
redirect, Mr. DiVincenzo?
Yeah, I got a couple actually. All right. So thank you so much, Mr. Fisher. I hope you weren't too, rattled or shaken or whatever's, if you have any EMS, you let me know, okay?
Okay, thank you.
All right, fantastic. Okay. So, let's talk a little bit about what Miss Thoroughbred had asked you, Counselor Thoroughbred. So, you came to the scene and you were told that the car is parked illegally, right?
That's correct.
Okay. So,
one more question ending in the word right.
Yeah, objection leading. Sorry, my bad.
Okay. All right.
I was making sure my client was okay. He's on the ground.
I'm sorry. I apologize. Okay, I just form a habit. Okay. All right. I'm reeling it in here.
Don't be Oliver Hull.
I got you. We wouldn't want to be that guy, would we? anyway. Give me 1 second. Let me go on to my thoughts here.
Dude, there's no way that motherfucker's name is Towington, dude.
All right. You know what? That's no further questions for this wonderful, fantastic, beautifully dressed witness here with his wonderful hat. Defense is going to ask at this time that the witness step down from the stand.
Well, that's what I do. That's my responsibility.
Okay.
So you can go ahead and step back.
All right.
Mr. Fisher, you can go ahead and step down.
Appreciate it. Thank you.
Your Honor, can we
Very
ask for
good.
clarification on whether or not counsel was flirting with the witness?
Oh, you know what? I am just always a good eye for a good dresser. I've only got one eye, so I value every time I see a good dress. So, I mean, you take with that what you will.
So are you saying my client's a bad dresser?
No, in fact, as you recall, I actually tried to ask him about those wonderful tattoos he's got. So, I mean, he's already...
Tattoos
dressed
are not
before he's even got-
clothes. Tattoos are not a fashion sense. They're an artistic choice.
Well, one man's artistic choice is another man's clothes, in my opinion.
Okay.
But
all
that's
right.
for an argument for another day.
All right. Enough of the back and forth. Mr. Silvio, any additional witnesses or evidence you'd like to highlight?
Yeah. I mean, I guess more dislike, not highlight, but dislike. As is made clear, plaintiff's B does not have a timestamp. So this photo could have been taken the day that this thing was filed. It could have been taken a day before the tow happened. It could have been taken before it got hit in the 30 to 45 minutes. So, don't take that picture at face value. Think about, did this really get taken at the time that the plaintiff is saying? And even if it did, maybe there was a guy that ran the car in and made it illegally parked at that point. As you know, there's a lot of crazy motherfuckers out there that can, maybe hit a car, and the car could have been illegally parked then marked for illegally
Understood.
parked.
Anything
then
further
federal.
that you'd like to highlight in the evidence rather than testify to me about?
No, nothing further.
Okay, very well. With that concluded, does the defense rest?
Yes, we do, Your Honor. We do rest.
Okay. All right. With the defense resting at this time, are we ready for closing statements? Do we need a quick minute, or are we going to be able to just go ahead and take these and just go
Let's
into
just do it. Send it. Full send, Your Honor, if you'd
I
be so
agree.
kind.
Risk it
let's
for the
hear it.
biscuit.
All right, let's hear it. Closings. Let's go.
All right. The day of January 7th, Damien Tinkerman had just one mission: to go ahead and work at Senior Buns, a place where people talk to other people and do not partake in the dirty, evil act known as filthy grinding. He had the plans to simply park his vehicle in a legally parked parking spot, a place he had parked many times and taken many pictures of his vehicle of time and time before, as he recalled the precedent had been set in the Old Republic, with Red Harrington. And Justice Montag.
Give you a little space, yeah, so you can subscribe in.
But nay, on January 7th, when he went to go take his legally mandated smoke break, after a quick 45 minutes of working on the job, as he was a manager and they're lazy and take many breaks, he found that his vehicle was missing. Tragedy had befallen Damien Tinkerman. His blood, sweat, life, and tears had been put into this vehicle, only for it to be taken dastardly by a Mr. Not Fisher, the other one, who's not here today, Mr. Hendrixx. Yes, and with that, we do in fact ask that this court rule with negative inference upon Mr. Hendrix's lack of testimony, as he must have moved the vehicle to make money when somebody else would come and finish the job. That's where Mr. Fisher came in. Your Honor, we believe that the evidence backs up this story, and that Damien Tinkerman will receive justice for his lack of vehicle to engage in his smoking habits. Thank you.
Dude, I'm so fucking zooted. I don't give a
Oh,
fuck.
that was so stunning. That was so moving. I almost forgot what I was gonna say, but I didn't.
So bad, bro.
Okay. Silvio, go.
Yeah, that was,
All right.
that was a good freestyle, bro, but holy fuck.
All right, here's the bottom line, ladies, gentlemen, everybody else, non-binary, whatever. All right, here's what's going on. So I've been towing for a bit, okay? Mr. Fisher, he's testified, he's told a bit. All you heard that in testimony. When you're going and you're doing those tows yourself, if you're that working blue-collar guy, you don't get all of the information that maybe you should be getting, that the exact time or something and when it was or whatever's. And that's on the plaintiffs to start proving all that, and they just simply hadn't done that. How do we know they hadn't done that? Well, let's take for example plaintiff B. Plaintiff B clearly does not show any time that this photo was taken. It could have been taken on a Tuesday or Wednesday or whenever the frick that they wanted to take that photo, thereby getting a quick, easy dollar. This is what this is. It's a sham because this guy's a hard worker. All right. I don't really know this guy, okay? But what I do know is he's a tow truck driver. And these tow truck drivers, they work freaking hard out there. And, they may not have all the answers, but they do what they can with the information they got. And the information that my client had at the time was that there was an illegally parked vehicle. And you heard in testimony, unconflicted testimony, that when he went to that spot, that vehicle was, in fact, illegally parked. Now, I am maybe of the opinion that Mr. Tinkerman doesn't have the most corrupt motives. Perhaps he did genuinely take that photo at that time. But the reality is that when you take that photo, it doesn't mean it's, a video camera. That car right there could have been moved. It could have been damaged, whatever's. And it could have made it illegally parked, as Mr. My Mr. John over here, Mr. John Fisher had testified. So there's just not enough evidence, certainly not a preponderance of the evidence, to find my client liable. Now, I'm going to be honest, all right? This Bili Hendrixx guy, I wish he could have been here to testify. But having said that, there really is not a lot of evidence here that Bili Hendrixx has done anything wrong. Now, obviously, there's a consideration of default judgment, but, if you put that aside for a moment and consider, Mr. John Fisher's testimony, he shows that this car was illegally parked at the time that he saw it. So it is certainly within the realm of reasonable possibility that that vehicle was illegally parked at the time that Mr. Hendrixx approached. Now, in the case that Hendrixx is given a default judgment, that does not necessarily impact Mr. Fisher. And that's a very important note because Mr. Fisher was simply the guy that got the message to go and tow it, which he gets completely different information than Mr. Hendrixx does. And so, therefore, from the testimony and from plaintiff's own evidence and from the information that this court has in their own beautiful noggin over there with that towing jobs and how they work, you combine all of that, and what do you got? You've got a not liable verdict. A liable verdict for John Fisher at the very least, and I would hope a not liable verdict for Mr. Hendrixx as well. Thank you so much.
All right, thank you for that. I'm going to be returning to chambers at this time for a brief deliberation. Won't be too long. I'll be out within 5 to 10 minutes tops. Court is in recess at this time.
All right. Hey.
Oh, finally, dude, it's recess. I thought that would never end.
You were in here the whole
Bro, if you don't win, I'm gonna riot.
You just got back. I saw you leave.
I just like
You little goofer.
Is he still awake over there?
Why are you
Well, that
pretending-
was
yeah,
his
he
time.
appears to be
Yeah, you
speaking.
didn't provide anything.
He doesn't look anything like me. Why
I
is he?
forgot to mention the totality of evidence.
Yeah,
Also,
Max,
it's
dude.
Saul. It's Saul. And
You
that's
look
Max.
and sound so fucking
Hey,
stoned right
Saul.
now.
I'm,
Yeah,
we're
okay.
both
Wait, what?
What?
We're both
That photo I sent both of you guys as an accurate representation.
No, I'm Adam.
You're not gonna trick. I'm not like Adam. You can't just trick me. I don't have memory issues. At least not
I
that
am
bad.
Adam.
You're not Adam. Who are you? I don't think I've met you.
I'm Adam.
You're not Adam.
This is Adam.
That's
I'm
Adam.
not filming. I
That's
just can't
Adam.
put down my camera right now.
We're going off to the
Yes.
side.
I'm gonna
10
be
guy.
honest.
Correct. I know that that's 10
What?
guy. What does that say about me?
Huh?
What?
Yeah, look, I'm pointing directly at you right now, but I'm not, right?
Bro, I don't even
That's not
remember
me,
getting up
correct.
there, but
I know.
did.
Now I'm pointing directly at you. Now I'm not. Now
Yeah.
I am.
Oh, okay.
Now I'm not.
Yeah. Yes.
So he's baked into
That's you. You're Adam.
you're
That's
pointing
I'm
Brick.
at
Ass,
And,
my boy.
and this is someone I don't know, but your name could be Adam.
You took a
You
photo
don't
of
know
your
him?
car because clearly this has happened to you before in the past.
Exactly.
You're the
It's
man.
multiple.
photos.
Yeah.
Like,
Okay.
I don't
Sorry,
know,
yeah,
like,
that's
Heck, I
thoroughbred.
freestyled
Yes.
everything. I was
think.
super high.
That's who got elected.
What?
I didn't
What?
prep
You're
for this at
high?
all.
Looks like a
I'm
regular
high as
human.
fuck.
He doesn't look like
Why
you.
is everyone high?
This is his last
Because it's
name.
a good day to be high,
His last
Turgle.
name, like a horse, like a
Oh,
stallion.
Turgle does not partake.
You know, like
Turgle, you should partake. When you say partake,
They
what
used
do you
to.
mean?
I don't think they have it
Oh, there he
anymore.
I
goes.
partook, but I don't partake anymore.
Yeah, it was a cover your ass
Going, Brick.
moment.
I watched this whole court case.
They
start to
do.
finish.
You don't have
You
to
didn't
do
want to get
anything.
I am
serious.
Adam. Adam, are you alright?
To do drugs.
Yeah.
the dude over, but it's like, they don't
Can't
have
Siobhan
anymore.
killed it.
I
I feel
that
my
guy
heart
seems
beating
related good.
and all the blood moving
Yeah,
through my
same.
body, and it gives me
Yeah.
I get a lot of
I
anxiety.
more if I
I
had the
don't-
evidence
I don't
in
like
front of
it.
me, but I don't have
Also,
access to
sit
that.
there like a piece of mush staring off into the universe,
yeah.
wondering when my heart's
Hey,
finally gonna
eventually,
explode.
right? Are you gonna be a cop very like?
I don't know.
Yeah. I just-
Yeah.
I just get really
I
sweaty
don't
and
think,
it's
I
bad.
don't think I'm gonna get hired.
Also, bro, oh fuck, I should have. Man,
Did you apply?
I applied. Yeah.
Did you have an interview?
Nope.
Hey.
Oh yeah, you're definitely.
Hey.
Yeah, I'm not getting, I don't think I'm getting
They
hired.
hate you now.
I hate
And he
that.
said
I
that he
know.
like Slacks hates you, dude. You know
I
Slacks?
know.
You met him?
I
You
know.
can see the
I
other
know. I
red
talked to
vehicle
Slacks.
that's
That's who.
Oh,
That's
right
who gave
over
me the
the
application.
barrier.
I was a CI for him at one point, actually.
Oh wow, how'd that
Gave
go?
him some cool information to get some guys in trouble that I didn't like.
What'd you get in trouble?
I don't fucking remember, but I got a free tire out of it. He let me use
Oh,
the car and
tire.
he had to walk out with some tires.
Thousand was gonna go to
That's cool.
Straight
I
from the
guess.
evidence room. Hell yeah.
Yeah. A whole
Awesome.
tire.
Oh yeah.
How much you get for that?
Yeah, so I mean, there's two
Totally
types of
legally,
uses.
and
What?
One
How
on
much you
the
get for the
Well,
tire?
back in the day,
I don't know. I put it in
you used to
Ingvar's
just use
trunk.
your
I forgot
common
about
noggin,
it.
you
though.
know?
Might
If,
still be in
if,
there.
if it seemed like someone's actual
All
car,
right.
it wasn't really like,
Like
you
2
know,
months
someone
ago.
called it in, you know, ask around, take
Miss
a
that
photo.
little guy. I trained that rapscallion.
Good, dude. He's a gangster now, bro.
Oh, he's a. I guess I didn't train him well enough.
No one's driving.
Well, we started our own like kind of gang
Yeah,
thing,
yeah,
dude. The suck and blow boys. We blow that loud cush and we suck the weed into our lungs.
You don't have to listen.
Gangster, right?
That's really hard. That's hard as fuck.
Suck and blow bullet.
Yeah, suck and blow bullet. Yeah.
That
Well,
is hard.
unfortunately, I can't do the suck part because I have asthma. But you know, the blow part.
Can't
That
do the
sounds
blow
pretty
part
cool.
either. Not blowing that loud.
No,
bro.
actually, you
No,
can do the suck part easier than the blow.
I don't understand how he
I can't really do either.
Well, yeah, I can suck it first, but I'm gonna die before I can blow.
I mean, when I was training my friend back in the day, I would go run around.
It's not.
Go and see your buns.
Doesn't make me a nerd. It's just it's a medical condition.
You know, I hate to be that guy, but I was like, let's just like work.
It's
It's science.
A nerd is
Science is
watching a
nerdy.
court case in its entirety.
Well, they're not gonna question.
That's what a nerd
When
is.
I
I did that.
question their
I did
toes.
that.
You know, they get the call. They're gonna go to it. They're gonna pick it up.
They're just
and
gonna
they're
take the
gonna
car, whether I
Exactly.
guarantee
Worn
you
that
he
chain?
wouldn't, like focus on if it was in a lane or not. He just saw the car.
Adam? No, he used to have a diamond dog
You
chain.
want the money.
Oh, I'm sorry. I didn't realize you were talking to me, sir.
He was kind of a Make-A-Wish member.
Kind of fucking
You have a Make-A-Wish member, Adam?
towing, and he just
Yeah.
fucking.
What? No. What? Of what?
No, they're
Of Make-A-Wish?
It's
They're
fucking
not a
true,
thing
bro.
anymore.
Yeah, I think Make-A-Wish is over.
Well, that's
Make-A-Wish is still a thing.
Is
Oh,
it? I don't think it is.
I thought Make-A-Wish was done. I thought it was over.
I think Make-A-Wish is, yeah.
No, diamond dogs are done. Make-A-Wish has still got to be going. What the hell else is John Cena doing?
He's
What?
got
Fuck yeah, dude.
The Rock, Johnson, and who else?
Bing chillin'.
Pete?
Yeah, he's doing Big
yeah,
Show,
he
that's
said
true.
that in that TikTok
Seen the-
thing.
You ever seen the minion that says Bing Chillin', dude?
Max is
Bing
yeah.
chilling. You like Rick? What's your number? I got something I want to say.
Oh, no, it is still going.
Just go look at the appeal for Murphy Brown again.
You see that Rick and Morty episode?
Oh, shit.
Welcome back, Your Honor. Great to see you. Hope you're
Thank
had a
you.
great time in your deliberation.
Oh my
so
god.
good.
Is that
the
Yves Saint
greatest-
Laurent cologne I smell over there? Oh my gosh.
It is.
Holy
it
shit,
is.
he went
it
Super
is.
Saiyan.
Usually
I thought it was
usually
awkward to show.
Usually I'm a polo black guy, but you know, I like decided to spice it up a little bit. Anyway, I want to thank everyone for their time. At this
59
time, I
different
have reached
chapters.
a verdict in this matter.
Make-A-Wish
It's going to be
Foundation.
kind of sweeping, so I encourage your patience. First off, I would like to highlight that the court notices that defendant Bili Hendrixx failed to appear for this matter. As such, I will be issuing a warrant for such. Mr. Hendrixx responded to the summons placed out via the docket, and there was a clear articulation that he was available at the time that this matter was scheduled. There was no indication or response given to the courts that he required any assistance in attending this matter, and further additional notice was served prior to this matter beginning. The courts will view this as ignorance of the summons. He is to be issued a warrant for 50 months in prison and a $2,500 fine.
Yeah.
Holy shit.
Beyond that, after
Wait, how
review, this court
much?
finds that the preponderance of evidence has been met to indicate an improperly impounded vehicle. I want to emphasize preponderance of evidence. Now, the courts are also going to find that Mr. Hendrix's failure to appear will be held in negative inference, and will be finding him responsible as the individual who requested the impound in full for the $1,600 requested in damages. The court finds that while guidelines may not have been clearly spelled out for tow workers at the time, there is a colloquial understanding through the unauthorized parking charge in our penal code as to what an illegally parked car is. I'll remind the court for the following. That means that if you park in a, quote, area that is unsafe or on government property, on a sidewalk or curb, in front of a red line, facing in the wrong direction of traffic, in front of a fire hydrant, or across multiple parking spaces, that is an unauthorized parked vehicle, and those vehicles are going to be subject to tow. I also want to lay out the following recommendations and guidelines for all tow drivers going forward. First, when you are marking or requesting that a vehicle be impounded, you, the requester, are to take a photo showing that the vehicle is illegally parked. 2, when collecting a vehicle as the driver, you also are to take a photo showing that the vehicle at that time is illegally parked. And 3, those photos that are taken must demonstrate that the vehicle is parked in an unauthorized manner, such as through the methods and means described above, previously. This documentation will afford you as the tow driver civil protection from liability in these matters. Further, and in closing, I advise that all individuals performing tow duties refer to the legislation titled, quote, Tow Clamps U, which was published on January 28th, 2023 by Chief Justice Alan Crane. by vote of the City Council. In doing so, you will find that the guidelines that I have just outlined are in line with previously published legislation and are to apply to all tows going forward. With that said, this court is adjourned. Mr. Fisher, you are free to go at this time.
You won. You got